Start. The findings of the trial court with respect to preliminary issue of limitation are based on the relevant dates revealed from the pleadings of the plaintiffs in the plaint itself. Stop. True that in the plaint it is repeatedly alleged that the relinquishment deed was obtained fraudulently by the fifth respondent. Stop. However, conspicuously, its date was not mentioned. Stop. But then the plaint averment is that their predecessor-in-interest, Shri Nahar Singh, on coming to know about the use of the said relinquishment deed, had preferred an objection on 5.4.1991 to the authorities, whereunder he sought not only for its cancellation but also on the ground of obtainment by playing fraud for refraining them from issuing allotment of the alternative plot in the exclusive name of the fifth respondent. Stop para. In this context, it is also relevant to note that going by the plaint averments after the death of Shri Nahar Singh on 14.5.1993, the original first plaintiff, who is none other than one of the sons of Shri Nahar Singh, filed representations on the lines of the objection taken up by his father. Stop. Even if non-mentioning of the date of relinquishment deed is not taken as purposeful, that cannot and will not therefore save the plaintiffs from the inescapable, adverse finding on the question of limitation to bring in a suit against the said relinquishment deed. Stop. Evidently, suit number 410 of 2000 was filed only on 14.6.2000. Stop. Thus, it is very much clear from the plaint averments that the relinquishment deed is anterior to the date of letter of intimation to the fifth respondent in bracket 8.3.1991 bracket out, and obviously, the date of objection against the same was firstly preferred by deceased Nahar Singh, viz., 5.4.1991. Stop para. Evidently, the aforesaid two dates specially mentioned in the plaint were taken into account by one, the trial court, as also by the first appellate court and the high court in the matter of consideration of the question, quote, whether the suit was barred by limitation. Stop. Uncode. The manner of consideration by the trial court, which ultimately resulted in dismissal of suit number 410/2000, would reveal, as stated herein above, that it had determined the preliminary issue regarding the period of limitation with reference to the averments in the plaint. Stop. The dismissal of the suit was in accordance with the decision on the said preliminary issue. Stop. Since we have already extracted the operative portion of the trial court judgment, we do not think it necessary to refer to its reasons and findings. Stop para. The pleadings in this appeal and the arguments advanced would show that till date, with such a prayer, no competent civil court was moved by the original plaintiffs and also the appellants herein. Stop. In short, in the absence of any successful challenge against the validity of the said relinquishment deed by making proper prayer in an appropriate proceedings, and that too within the prescribed period of limitation, the conclusion and finding of the first appellate court, as aforesaid, cannot be said to be perverse or illegal, as there can be no doubt with respect to the position that consideration of validity of a relinquishment deed and consideration of the period of limitation with reference to the same are different and distinct. Stop over.